I did post the CLE information in the chat as well. If you have other questions, I will post it in there. And like I said, I'll be monitoring the chat while Rebecca's giving the presentation. Thanks so much, Rebecca.
Okay. And then this one is also your slide.
We are hoping that anyone who's attending today will take a case. That's why we're giving you the CLE today and that Rebecca is hosting or presenting on, is because we're hoping that you will actually take a probate case. If you want to take a probate case, you can log on at our portal at hbl.legalserver.org. We're going to be offering a series of CLEs this week and the next following 3 Fridays. This week is probating wills and probating wills as a muniment of title. Next week, we'll be doing an application for letters of administration and determination of heirship for when there's no will. The third week will be small estate affidavits and affidavits of heirship. And then the fourth week will be ancillary matters, things like drafting deeds, helping with HCAD forms, potentially an IRS matter. And so we will do that the fourth week, and y'all are welcome to attend any week. You can log on at the portal, or you can contact our pro bono staff for more information about taking cases. Thanks so much. And I think one more slide, right? We have a medical legal partnership with Texas Children's, and while it's not technically a probate matter, guardianships are done in the probate courts, and we would like to encourage everyone to take a guardianship case as well, or consider taking a guardianship case. There's a couple of reasons why you would want to consider doing it, and through our medical legal partnership, you're helping parents care for the disabled children as they enter adulthood. Their parents aren't able to help make decisions for them, medical decisions, if they don't have the guardianship. They have to have an attorney, and they can't do it pro se. The HBL guardianship cases are uncontested. We don't take contested guardianship cases. The probate courts are a friendly court. You'll find that for probate matters and guardianship. And we are told that the probate courts love our HBL volunteers. HBL will also provide templates and mentorship throughout the process. And just so everyone knows, if in order to be an attorney in a guardianship case, it does require a 4-hour CLE. The 4-hour CLE costs about $200. If you sign up to take a case, we give you access to that CLE for free. And I think that's the end of my segment. Thanks so much.
Okay. So this is today's topic, which is where there's a will, there's a way, probating wills and probating wills of muniment of title. So the decedent is the person, the testator, the one that died. The first thing that you need to do is determine where they last resided, owned real property, and their location of their death, and then determine the date of their death. And that's important to determine, which venue is proper, if it's proper to be here or somewhere else. The next thing you want to do is you want to locate a will. If you're probating a will, the original will is needed. There are extra steps if you don't have the original will. So you really want to locate that original will. You want to determine if the will is original with signatures and it has all the necessary. So if it, for instance, you want to determine if it's holographic or typewritten. If it's holographic, only the decedent or testator would have to sign. However, if it's typewritten in any form, so if they write out one page, type another page, and then write out the third page, if there's any typewritten or any part of that will is not wholly in their handwriting, then it has to be treated as a non-holographic will, and it requires 2 witnesses, notary, to be valid. So you need to make sure that it meets all the criteria to be a valid will. You want to see if there's a self-proving affidavit within the will. Otherwise, you're going to have to get the witnesses for those and have them to prove up that they did see the person sign and all that. I did contact the courts, and they said the most common things that they see are the attorneys don't check to see if the will is actually an original will. And they said, take the original, because you have to turn in the original will to the court, check it and check for indentures in the ink to see if there's pressure marks from where they signed. Check to see if there's copy machine lines in the paper of the will that signifies that it was sent through a copier. And then see if the lines overlay the type lines, the written lines overlay that. And they said that's a common mistake that a lot of people make. and then they have to make you go back and try to find the original whenever you do that. The next thing you want to do is make sure that the will disposes of all the assets. So if the will says, I'll give the car to my brother, the house to my sister, and that's it, and then he has other assets, well, then it's a part will probate and it's a part intestes probate, and you have to, the will can only digest what assets are in the will, but you still have to have a determination of heirship to determine where all the other assets from the estate would go. And then make sure that you have the proper consent in the will for a will of independent administrator or independent executor. So there should be something in there that says that they're authorizing that person to be an independent executor, usually without bond, sometimes with payment, without payment. But you just want to make sure that all of that language is in the will as well. Otherwise, you might have to do extra steps along the way. When you take a client, some of this is going to be done by HBL when they screen the people out, but you just want to double check it. So you want to make sure that they have standing to bring probate action. And so in the statute, it says, that definitely anyone that's named in a will, the heirs to the estate, if there are no heirs, a creditor can. And so anyone who has standing per, you want to just make sure that person is the one that is your client and not the brother of a sister of a cousin. Is the client the named executor and administrator designated by or authorized by section 254.006? So in the case of the executors in the will, maybe they don't want to serve, maybe they've passed on, maybe they've become incapacitated, or for any other reason they can't serve as an executor anymore. All the beneficiaries of the estate named in the will, they can consent and name someone else as an executor. And so you can also have that as well. A client is qualified to serve if they are not a felon, if they're not incapacitated. They have to reside in the state of Texas, or if they reside outside the state, they have to appoint a resident agent, which they could appoint you as their attorney, and then they can serve. And then there's another one in here that says the court can disqualify any person from serving as an executor if they find that it's unsuitable. Now, case law out there doesn't really identify or have clear boundaries on it when someone is unsuitable. And so there is a lot of discretion with the judge. The most common, though, that have been upheld are when the self-interest of the executor is adverse to the estate. So if the estate own, or if the executor is trying to say, I own a house that is also being claimed to be owned by the executor or by the estate, well, then that's adverse because that outside lawsuit could deprive the estate of assets. And then if the named executors are gone, are not available, well, then is there a potential conflict between the heirs and who would be named as an executor? And so you want to look at that too. Venue. So venue is proper in the county of residence of the testator. So if someone had lived in Harris County, that's where you should file it. However, if they don't live in the state of Texas, but they died in the state of Texas or county in Texas, or if they have real property in a county in Texas, then you can also use that as well. The application. So this comes right out of the statute, and all of these items are required in the application. Most of the text docs and pro docs and stuff, they already have parts where they ask you for all this, but you just have to look and see. Now, if you don't know a piece of information, so say you don't know what the testator's driver's license or social security numbers are, all you have to do is put a statement in there that that information is not available to you at this time. Um, if there's other information missing, you have to briefly give a statement on why you can't get to that information. And then the judge would have to say, yes, I'll allow it to go forward, or no, you need to go back and find that information out.
Rebecca,
Yes.
we have a question that says, does venue require real property or does personal property count, like bank accounts?
What is the question exactly?
Does venue for like what county to bring it in, does it require real property or does personal property count?
The actual statute says real property or
Thank you.
real estate. So it can't be personal property. And you would assume personal property can move. So you can pick up a car and move it to another county, and then you shopping. So it would need to be, the statute is real property. The filing of the probate. And so, as you know, Texas is e-filing. So when you file your application, you want to mark a copy of the will as an exhibit. Now, it's always going to be a copy because you're going to have to scan it in and upload it and send it. However, before you'll get a hearing, even to be set, I think even before they'll post it, the clerk is required to have the original will. And so HLV's, HBL's policy is that filing should be there, that original will should be with the clerk within 3 days. Currently, because of COVID, you have 3 ways to get it to them. You can mail it to the clerk. They have a drop box outside the courthouse, or you can contact, if you go to their website, they have a link where you can contact them and set an appointment where you can go in there and give it to them. Now, the other thing about this is if you have a lost will and you have a copy of that will, whether it's signed or unsigned copy, but anything that you're purporting is a true and correct copy of the last will and testament that was signed, you have to physically take or submit a physical copy of that copy, which kind of seems redundant since it's a copy and you can e-file it, but they still need a physical will dropped off, or mailed in, dropped off, or with an appointment. And then after they get the filing, the clerk, once they accept the filing, they will post it, and it has to be posted, I believe it's 10 days that it's posted on the doorsteps of the courthouse. And you can't have a hearing until that time has lapsed. So citation, or the notice is given by posting on the courthouse. So you don't have to send, at this time, you don't have to send personal citations to all the heirs or anything like that. All you got to do is have it posted. However, if the will is over 4 years, or it's a copy of the will, you have to have personal citations or waivers from every heir and beneficiary. So if if a will cuts out an heir, so say you had a grandfather that gave to 3 of his children but cut out 1 child in his will, which he's more than capable of doing. If the will is over 4 years, or it's a copy of the will, you are required to serve that kid that was cut out of the will. And that's under Estates Code section 258.
Rebecca, one more question. If a will is not turned in stapled, if it's been unstapled, does that ever present a problem?
I haven't had it present a problem.
Thank you.
You're welcome. Ancillary documents prior to the hearing. So before you go to your hearing, they'll give you a hearing date, but before you go to your hearing, you want to go ahead and have the proof of death and other facts completed and signed. The oath you will draft, but it cannot be signed. It's the oath of the executor. You cannot have your client sign it until after they're appointed. So that when you file it, it will be a blank one. And then the order admitting the will, the probate, and authorizing letters of testamentary. After your hearing, in the past, before COVID, they would have you move down from the bench to the clerks of the court, and the court would swear your client in for the oath. Now, because of COVID and they're doing everything by Zoom, they're allowing unsworn declarations on those, or having them notarized in your office, and then you e-file the notarized copy after the hearing. But be careful if you have your client come in like on a Friday morning before a hearing the following week, that you don't have them sign it and notarize it then, or sign it then with the date on the unsworn declaration, because it's not valid until after the hearing and they are appointed. So you call the court and you set it for a hearing. And the only requirement is that it has to be out after the posting. You can't do it before the posting. And so when you call the court, you'll ask them, because it doesn't always get posted the very next day. They have dates on their calendar where they start and stop posting. So if you call, you can ask them, when will it be posted? When will it be done? And they will look it up and they will tell you, okay, you can have a hearing anytime after this time. They'll also tell you how many people are on the docket, because they go strictly by the number on the docket. So if you want to make sure that you're not number 30 and waiting and, for the court to hear you after an hour, you can say, hey, can we put it to the next week and get me on the 1 or 2 spot? So, and they'll work with you on that too. The best resource that I have found is each one of the Harris County courts has a staff attorney. And so if you ever have a question on, hey, it's not like other courts where if you call, they say, oh, I can't give you any legal advice. These staff attorneys, if you call them up and say, hey, will you check my file and make sure I have everything filed and I'm ready to go, at least pleading wise and document wise, they'll do that. A lot of times they'll do that anyways. And sometimes you'll get a call before your hearing and say, hey, we're missing this. But if they don't do, because they don't do it on every single time, and sometimes it's because they've gotten too busy, but they try to. But if you ever want to just make sure, you can call them and ask them. And then if you're missing something, they won't necessarily tell you that. A lot of times what they do is they won't say, hey, you need to file this and this. Sometimes they will if it's something that's pretty obvious or something that's pretty general. But a lot of times they'll say, go read this section of the code and make sure you're compliant with that. But they will actually pinpoint the area where you need to go fix. And if you don't understand it, sometimes you can call them up and say, hey, I'm not really understanding this. Why is this? And sometimes because of the way the statutes are read, that sometimes the procedures in the courtroom are a little confusing, but that is your best resource, is just to call the staff attorney, and they're all listed on the websites for each court. And I've had tremendous luck asking them questions from time to time, because they are a resource that you can use. Prove up the application and request for administration. That's the other thing, is you need to be prepared. You need to make sure that your application is requesting for an administration. So if you only file an application for probate and you don't file within there, ask something for a request for administration, then the will will be entered for probate, but you won't have an administration. So make sure that those documents are in there. But when you do, you're asking for both. So the hearings are currently being conducted by Zoom. And then I already said the oath will need to be signed after appointing the executor. Request your letters of testamentary. Those letters are requested by the civil clerk, not the court clerk. And so HVL recommends that you get 5 plus 1 for each financial institution. So anything that you do, you need to do it. Now, generally, the letters of testamentary are only valid for 90 days. And so if you're in the process of putting a house for sale, or, to sell the house to get the proceeds, and you don't think that the house will be sold for 90 days, you're going to have to go back and get another one. Now, each letter of testamentary is $1, so it's not like a big strain on the pocketbook to get a couple extra and let them time out, but you can go back and ask for another one, to get, as long as the judge gives them, they're still assigned as for the administration. After the hearing, you're going to want to publish with the newspaper, and it's usually language similar to, it's a creditor notice, and so that is for people just to get general knowledge. And so you can do it with any paper in the county. So you can call around. They're roughly about the same prices when I go around and use them, but HVL has an agreement with the daily court review, which offers a 50% discount from HVL clients. So there is a sheet that HVL gives each new lawyer that comes in with information, and the information to go through the daily court review is located in that information. Then you need to send certified notices to secured creditors. And then you want to determine whether or not you want to send certified notices to unsecured creditors. So the general rule for creditors is if it's secured, you have to, and that's secured like a mortgage or a car, where it's secured by property in the estate. Now, unsecured creditors like credit cards, if your clients, the estate with the client, say they have $40,000 in credit card debt with 3 or 4 credit cards. And so it's pretty high debt all around. Well, once you give them notice, they have a deadline to send back the information, and probably 75% or so of the creditors never send back. So they waive their ability to collect that. They waive their notice to the estate to get paid. And
You mind if,
yes,
I'm sorry, I was going to say it creates an affirmative defense. And I've been told that MD Anderson always does it correctly. So if they're one of your creditors, just be aware of that. Are there any other people you just want to mention this for?
I don't know off the top of my head, but you have, including with the secured creditors, you are required to send it to any medical, so hospitals or anything of the last where if they passed away. So, and there's a hierarchy of who gets paid. And so they will usually always, all the hospitals and stuff, when it's the last illness, they will usually always come back and say something, and issue a notice. Now, credit card companies, cell phone companies, stuff like that, they hardly ever do. And so if you have big bills, because they do have 4 years to come back and issue a claim or come back and actually do it if you don't notice them. And so if you have one that's like $100-$200, sometimes I ask them, hey, do you want to do this? No, we'll just, if we have to, we'll pay that later. But if it's a big one and it's like a credit card company or something along those lines, they usually get so bogged down that I've had them where they've written off like $8,000-$10,000 regularly because they didn't timely file a response, and they have 120 days to make that claim. So it's 4 months, and the companies are so big, they don't process that correctly. The next thing you need to do is an inventory. You need to serve all the heirs with the citations or get waivers. I get a lot of people who come back and they'll just sign the waivers because they want their money as fast as they can. And then after that, a lot of times, what I will do here, which is not required, is I try to get a settlement agreement with all the heirs, just so that there's no dispute or contest later. Even, and it can be simply that everyone was paid their portion from, just an acknowledgement, basically, that everyone was paid their share of the probate of the estate. and then file the agreement and the closing letter with the court. And then your case is done on that. Now, Muniment of title. What happens here is a Muniment of probating a will and a Muniment of title can save the estate a lot of money if there's no need for a full-blown probate. So when an administration of the estate is not necessary, so you're not collecting debts or collecting assets, you're not selling property, you're not paying off things, then it's pretty easy. So usually you're not really doing much other than, hey, you might go get a bank account, or you might go get, one house that's secured by a lien and selling it, or one car, something that's very easy. But there should not be any other debts on the property, or any other debts in the estate that would need to be cleared up. And so this is just, hey, we're just going to pass this along. Like, we're just going to change the title on this. You can also use a Muniment of title if it's been more than 4 years since the testator died. And this happens like if mom and dad both own a house. Well, dad passes away in 1970 and mom never probates the will because it's her house too. And so then mom dies 20 years later, and all of a sudden the kids find out that mom never probated dad's will. And so you can use a Muniment of title to pass dad's portion to mom or whoever it was supposed to go to, and then you can do mom to whoever. So then they can get rid of that property. But that's the most common that I've seen, is when it's a spouse that's lived together and one spouse passes away and the other one doesn't do anything because they don't think that they have to. And then later on, it needs to be done later on. It gets messier as time goes on. If it's more than 4 years, you have to give the court a reason why it wasn't probated before. And it could be simply, hey, I was 4 at the time that my dad passed away, didn't realize that mom didn't do it until I was 27.
Rebecca, can I clarify? Is that when you're trying to probate the will after more than 4 years, or probate the will as a Muniment of title?
As a Muniment of title. You cannot probate a will at all after 4 years.
Thank you for clarifying. And the court does still require some sort of reason.
Yes.
And just is ignorant, for lack of a better word, is ignorance a reason? Like, I didn't realize I needed to probate it. Not even I was 4. I was 25, but I didn't know it needed to be done.
They have, what I've read is a lot of courts will just allow it if you give them any reason at all.
Thank you.
Because there's other, they know that you're just trying to pass the title to the correct person.
Thank you.
So, but that's it. So there is a Medicaid recovery program now. And so this is language that whenever you probate a will as Muniment of title, it has to be included in I believe it's in your application, and I think it's in the order admitting the will to probate. But this is the new language. It says, if the person has had a Medicaid claim anytime after March 1st, 2005, applied for it, obtained it, whatever, you have to have the sentence, the Texas Department is waiving any claim against the decedent's estate. So you have to contact Medicare, Medicaid, and get them to agree to do that. If they don't, then they are a debtor because they're entitled to have reimbursement if they've paid out funds for this person while they were alive after 2005. Now, if your decedent never applied for or received Medicaid benefits after March 1st, 2005, you simply have to put a notice in there that says they didn't apply or receive services.
And may I offer a little bit of clarification on this one too?
Mm-hmm.
That document's called a MERP cert for short. If you ever hear anyone say that, that's what they're referring to, Medicaid Estate Recovery Plan Certificate. And they waive it in a almost any HVL client would be eligible for a waiver. Even if there is a claim against the estate, that almost all HVL clients would be eligible for a waiver, just so you know.
So, so that is that. The application for the muniment of title, it's pretty similar to the application to probate a will, except for, like the debts aren't in there. There are some things that you don't need, but it's straight out of the statute. And you just want to make sure that you have it in there. Again, if any of the information that's listed here is not in your application because it's unavailable to you, you just have to include a statement on why it's not available to you. And then the judge would have to determine if that reason is a good enough reason to go forward or make you go back and search for it some more. Filing the application, again, you have to file a copy of the will and the original has to be provided to the clerk. You would need then to file your proof of death and other facts. On the muniment of title, probating a will via the muniment of title, you don't need an oath because there's not an administration taken at this point. At your prove up, when you're there proving it up, the statute is clear on what you need to actually prove up, and it's pretty simple. Testator's dead, 4 years has not lapsed. Now, if you are in a situation where it has been more than 4 years, you do need to give a reason why that you need it as a title transfer and the reason why it wasn't done timely. That the court has jurisdiction and venue over the estate, so you'll show, hey, there was the properties here, he died here, something, he resided in Harris County, something along those lines. That citation has been served and returned. Again, if it's been more than 4 years, you have to have the actual citations on the heirs and beneficiaries. If it has been less than 4 years, then it could be by posting and then you file afterwards, but you would have to have the citations back before you actually did your final hearing. You have to also tell them that the testator never revoked the will. And all of these your client can just testify to. It was interesting to note that on the prove up of the muniment of title, they want you to actually tell you that the will is valid, that the testator was sound mind and over 18, married or in the armed forces. You can also, as a muniment of title, you can get a declaratory judgment construing the will. So it could be that there's not any real property to change, but there could be other assets that they just want, where the will isn't clear enough, where there's sometimes they'll say, hey, all of my heirs get 1/3% or 1/3 of my estate. And then it might have a special bequeath of, hey, but my son gets my car. And so they might come back and say, well, that's ambiguous. Does the son get the car and that is included in his 1/3 share? Or does he get one? Do we take the car out of the estate, divide the estate? He gets 1/3 of that plus the car. So you can use a muniment of title to come in and have the judge do a declaratory judgment to say, hey, this is how it should be interpreted. You don't need an administration, you just need an interpretation of other items that are in the will. And so you can use that as too.
Rebecca, I missed a question just that would have been appropriate on the other slide. Is there a requirement for publication or citation with a probating a will as a muniment of title?
No, there's not. There's not a requirement for publication because that would be a noticer's credit. And under muniment of title, you can't have any debts.
And for personal service?
For personal service, I believe it was to the heirs and the beneficiaries.
I believe you're correct as well. Thank you.
You're welcome. Actions after judgment is you have to file So after you get the judgment, you're allowed to use that judgment to do any transfers of property that are needed. So if the muniment of title says, okay, we're going to transfer this house from dad to mom or dad to mom's estate or whatever, then you can do that with that order. It's kind of similar to a dependent administration where the court orders that you can do certain things, but so you can only do that thing. If the court only orders that the house be changed, you can't change other things. Like you couldn't go and change the townhouse across town. You can only do what's listed in that order. And then a report within 6 months of the date that the will is admitted to probate, your client is required to give a report to the court and saying, hey, within the will, we did this and this and this, but we did not do X, Y, and Z. So if you transferred a house, but you did not transfer the townhouse, then you just have to tell the court, these are satisfied, these are not. And so they can use that. So if someone else wanted to bring that and ask for that, usually what you're going to try to do is fulfill as much as you can in the Muniment of title, not to make it to where it's not necessary to do anything extra. I think that is it. Once you transfer the property through a Muniment of title, it's good legal title after that. And then that, I think that is all. If we can take questions right now.
Thank you so much, Rebecca. I really enjoyed it. If no one else, I'm willing to give more questions. Someone asked about filing the Muniment of title in the real property records. HVL does recommend filing the Muniment of title in the real property records for a real property transfer.
Yes, you would need to, because even if you're just probating and you're changing, even if you have a dependent administration, the real property records and the probate records are not commingled. So you won't be able to show that the property's been transferred or done anything until it's actually it's recorded with the real property.
So there's a question that says, for Muniment of title, what happens if the decedent, I think this means it's decedent, not descendant, has property in another state? I don't know the answer to that one.
Okay, so my understanding is, I don't really know. I believe that the probate of this state would transfer from other states, but I guess you would have to go and look in the other state to see if they would allow it. And so I believe they would, but it would always be a state by state.
Okay, and I have someone raising your hand. If you want me to allow you to speak, I can do that. Just 1 second, or you can type a question. Just 1 second. I'll allow you to speak though. As soon as I find you, just 1 second. I don't know, John, I don't know why I can't find you in my list, but I would allow you to speak if I could find you in my list. Oh, hold on here, just 1 second. Okay, you're allowed to talk now.
I think you're on mute.
Can you hear me now?
Yes.
Okay, I had that situation in Florida. And even though I'm also an attorney in Florida, they would not let me file the documents from Texas in Florida. I had to start a whole new estate.
Okay.
So it's state by state. I can't say that would happen anywhere else, but I did have that experience.
Thanks for the feedback.
Sure.
Any other questions? If no one else has questions, you don't mind staying on longer, I have tons of questions all the time. Oh, you're laughing. I was just going to point out that another reason that we sometimes might recommend probating a will as a Muniment of title is that there may not be anyone qualified to serve, because there's no administration, there's no executor appointed, so you don't have to meet qualifications. And occasionally we have situations where maybe everyone in the family does have a felony or something, but it doesn't mean that we don't think it means that they should lose a house, just so y'all know.
Yeah.
We are not doing dependent administrations in this presentation. That and in general, HVL doesn't accept dependent administration. Someone asked to talk about dependent administrations. Oh, I'm sorry. I'm sorry. Do you mean I take that back. I take it back. Generally speaking, HVL doesn't accept cases if we think it's going to be a dependent administration. There'd have to be some good cause as to why we would accept that. But do you just want to talk a little bit about when there's a dependent administration and maybe what we're looking for to determine if there would be one?
Yes, so usually in a dependent administration, it's usually when there's not a will and it's intestate. So because the only way you get an independent administration is by having a will that says that it's an independent administration, or when all the beneficiaries of the estate agree that it will be independent, and then the judge has to grant it. So all others are dependent, which just means the court has to agree or approve every transaction that the executor makes.
But you can also have a dependent administration if the will doesn't appoint an independent administrator and the family doesn't agree, right?
Right, that's part of it. You know, the will
Okay.
has to either appoint it or they have to agree.
How specific does the language have to be regarding, like, do they have to, sorry, I think I know the answer to this. And when I've read the code, it doesn't say that you actually have to use specific language to have a independent administration. They want to follow the intent of what the testator was writing, and it doesn't have to use specific language.
Yes, but a lot of times the people that are writing the wills, if they're laymen, they don't understand that you even need independent. And so they don't even know how to put the intent in there at all. So a lot of these legal Zooms and whatever, they, other form builder type programs that you can buy your will, sometimes they'll have the words independent administrator and they just click it and say yes. But usually if someone doesn't know, then they don't have the language in there at all to even show the intent.
That would be another time that maybe we would want to probate a will as a muniment of title if it's a possibility, rather than probating the will. It just might be easier than a dependent administration.
Right. And the other thing is, you can, if the family is going to agree, the family members can agree that it's independent. So if you only have one heir to the estate, it's going to be independent because you can agree on it for yourself. If there's only one or two sisters or brothers or kids or, heirs at all, they will sometimes agree. The times when it gets more difficult is when there's 10 children to this couple and one of them has passed away. So then there's grandkids, and the more people in the pot, it makes it a lot more difficult to get an independent administration if it's not in there correctly.
I agree. I also just wanted to say that to anyone who's taking a case through HVL, we have access for our volunteers to the Texas Probate Manual, which has forms, and we also have access to text docs, which was created by the person who founded ProDocs. After he left ProDocs, he started Text Docs. So we do provide access to both of those for any person who does take this, because I think probate is largely a forms-based practice. And like I said, most of our cases are uncontested for a variety of reasons. And so it really is largely just forms-based.
So I got a question on here. I don't know if it just came to me, but it asked about if it's not self-proven and there's 3 witnesses, do you have to have all 3 as witnesses? And no, you don't. You just have to have 2 of the witnesses show up as a requirement.
And just so you know, we've also had the situation if it's notarized but still not self-proved, because notaries like to do wills too as a service, and they don't necessarily do it right. The notary can also be a witness, even if they were technically like a notary for the process, because they notarized the will, but they didn't notarize a self-proving affidavit.
Mm-hmm.
There's another question, or another person that says they advise clients to check Claimit. claimittexas.org. I think you're talking about the Secretary of State, Unclaimed Texas. I see it now. claimittexas.org for unclaimed property. I tell people to check it too. Just so you know, for unclaimed property, depending upon the value of the property, depends on whether or not you actually need a probate of a will or anything. If it's less than $5,000, you can use an affidavit of heirship. If it's between $5,000 and $10,000, you can use an affidavit of heirship, but it has to be on file in the real property records. If it's, I actually wrote this down recently, 10,000 to 50,000, you have to have a small estate affidavit. And if it's 50,000 or more, you need a determination of heirship. How long can someone contest either a probate of a will or a muniment of title?
I honestly don't remember off the top of my head. I think it's 1 year or 2 years after filing.
I'm going to check because I actually thought it was 4 years, but I'm going to check now. So if someone else wants to come up with another thing, I think we'll both be checking. And if anyone else here is a probate expert and wants to answer, but I'm always checking my statute of limitations because I don't want to give the wrong information. I think it's 2 wills from the date the will is admitted to probate.
2 years?
Thank you. Thanks for it. We got 2 responses too that also say 2 years. And I think it's from the date it's admitted.
Okay.
So don't listen to me.
Well, they gave a code of 256, which is what I just found in my index.
Are there times that someone comes to you with a will and you recommend not probating the will as regular or as a muniment of title?
I have when it was, I think the only property of the decedent was the personal property and a car. And so you can use a affidavit if they have a form at the DMV or the Department of Motor Vehicles where you can fill it out, sign it. It's almost like an affidavit of heirship, and you file it with them, and then they will transfer the car. And then personal property, you're just like, okay, you can divide it up amongst the heirs. Now, anyone has a 4-year period to do it. I've also advised, I've had people who've come in, for instance, my father had passed away and the only thing he had was a house. It was paid off. He didn't have any debts or anything like that. We weren't planning on selling the house for 4 years. So we just filed an affidavit of heirship with the real property records, and it vests after 4 years.
I think it's 5 years now.
Okay. Well, at the time, this is over 10 years ago when he died. So it was 4 years back then.
Okay.
But,
Yeah, no,
but when it vests, then it's free and clear. And technically, you can do it from the beginning, but the reason that it takes so many years to vest is because creditors or whatever have that long of a time to come and file a claim. So.
And I've also spoken with some probate attorneys who've said that they've gotten title companies to accept it on the spot when all the heirs have signed. I don't know how you prove it's all the heirs, but I've heard that you can persuade some title companies to accept it, but I think you have to talk to the right people to persuade them. There's some more questions in the chat box. Just one second. Okay, there was a clarification on contesting a will. If there were disabilities or someone was a minor, then it's 2 years after the disabilities are removed or someone turning 18. And then it says that, can you repeat the information on when you would use an affidavit of heirship versus a determination of heirship? I think you listed the dollar amounts on the estate property. Do you want to take this or do you want me to?
When you were talking about the dollar amounts, that was with Claim It Texas.
Yes, for unclaimed property.
As far as I ask my clients how long, like if you're transferring a house, I ask them how long, if they're planning on selling the house, because it takes so many years to vest. So a lot of times they can't get it sold within those many years. So if they're planning on selling the house then to get the proceeds out right away, then you can do a determination of heirship or probate. A lot of times I tell them to go and talk to the title company that they're planning on using to see which one that they would accept, because title companies can be really hard to deal with on those certain things. But if they're planning on just switching the title and keeping the house in the family, well, then I just tell them to use the affidavit of heirship, if that's the only thing. Bank accounts, if there is a bank account, a lot of the banks will not do anything with an affidavit of heirship, even though the statute says that they can't be, they're immune if they rely on the affidavit of heirship. but they still won't do it. They will require a determination of heirship before they will release funds. And so you ask, well, how much funds are in there? Because it's going to cost them a pretty penny to go and do, because there's an ad litem that has to be assigned. There's publication and all that to do a determination of heirship. And so sometimes it's not worth even going after that money, maybe waiting until it gets to claim at Texas and then doing it that way.
I have actually recommended some people just wait because the value is so low. It's not worth any action. It's better just to wait. I agree. With a determination of heirship, you always have to have an ad litem appointed, which adds to the expenses. If next week we're going to be talking about the application for letters of administration for an intestate estate, and which requires a determination of heirship. And just so y'all know, if you do take one of those cases, the probate courts will appoint an ad litem for free for HVL clients, because generally speaking, we have simple cases. If we're doing those, we don't do very many. There was another question about what happens if the decedent prepared a proper self-proving will and then a subsequent holographic will, which to probate?
You have to probate the holographic will, because anytime you do a new will of any kind,
It revokes the prior will.
Right.
Thank you.
Mm-hmm.
Someone else is saying, oh, okay, so sorry, Rebecca, because you actually clarified what Eric's question was, I'm going to say for getting property from unclaimed property, if you're getting the property of a decedent, of someone who has passed, for up to $5,000, you can use an affidavit of heirship. 5 to 10,000, an affidavit of heirship that's filed in the real property records. 10 to 50,000, a small estate affidavit, which is signed by a court. And over $50,000, you need a determination of heirship, just FYI. And that's on the Secretary of State Unclaimed Property website. And then Catherine writes, she advises clients who don't want to probate a will that the estates code requires the will be deposited with the court. That's not something I was aware of, so thank you for sharing, Catherine. And just one second.
There is a statute in there that if you have the will, you do have to provide it within a certain number of days.
So someone else is saying that the problem that they see are when there's kids from outside the marriage. I would agree. So I'm just going to say with this, it also depends on whether or not something's Betsy, if everyone can read in the chat that regarding like children from outside the marriage, you know, if you have a will, of course, you can only just leave your share to someone else. And if you do have community property, it's correct. You can only you can still only give your portion to someone else. Your portion to your heirs. So yes, that can be an issue. Someone else said, do you know if the COVID-19 emergency orders extended the statute of limitations for probating a will? I don't think so. Do you? I don't know if that was one of the, I'm going to be honest, for the past year, I've been focused on evictions, and I can answer any eviction question you have about emergency orders, but not the will ones.
I didn't hear the question.
Did the COVID-19 emergency orders issued by the Texas Supreme Court extend the statute of limitations for probating a will?
I don't know if they did or not.
Okay. That's a fair question. You can find all of the emergency orders on the Texas Supreme Court or the OAC, the Office of Court Administration. Texcourts.gov, I believe, is the website, and they have all the emergency orders. In case anyone is wondering, they extended the deadlines for other things that affected us in probate court. Excuse me, in JP court for our evictions. I apologize. I'm using the wrong language. So I don't know the answer to that one.
Yeah. So going back to the one where it's children outside the marriage and the wife pays off the mortgage after the death, the value of the property is stopped on the date of death. So it's the value of the home with any liens or anything on it at the time of death. So if she does take her life insurance money, which is her own property at that point, and pays off the home, that's still part of her property. It doesn't transfer it to the kid's property.
Thank you. There's another question that says, is there any way to force the bank to reveal how much money is in a bank account so that a client can figure out whether or not it's worth the legal proceeding?
Not without a legal proceeding. Sometimes you just have to call up there and call multiple different times to get different people on the phone and just be really sweet and say, well, can you at least tell me if there's more than like 1,000 so I know if it's worth it to file? And sometimes you get someone on the other end that's finally like, okay, yeah, no, it's less than 1,000 or it's less than 5. And sometimes you call and someone's just a real big jerk and they won't tell you, no, I can't tell you anything, won't tell you anything. But you call up there later and do it really sweetly and nice. And sometimes they'll bend the rules a little bit and give you the information that you need.
I've heard the same thing as you, that if you say, can you just tell me if it's more than or less than? I've heard that they'll answer that kind of a question. And maybe you call back several times to talk to different people if you're trying to figure out how much more or less than. There's another question. Will banks accept the small estate affidavit?
A small estate affidavit is it's an order through the court. So I haven't tried it, but I don't know.
I've had a life insurance company do it, but you have to be very specific. You have to have the bank and the bank account number because there's no administration created. And so as long as you're specific as to the asset that's being distributed, then it's my understanding they will. But if you just list like bank accounts, I don't think that that's specific enough.
Mhm. That's probably true.
Someone wrote, I think in determination of heirship, if the client meets an ability to pay court costs, generally the county will pay for the ad litem. That's been our experience at HVL. They do. Do we need to file for CLE? No, you have to file it yourself. We're not collecting any of the little fill in the blanks. So you have to log on to get your credit. And if you go to the top of the chat box, it does have the CLE credit number. Someone's saying that they had an experience where a bank required opening of an estate account where the beneficiary info was unclear, even though there is a de minimis value. Is this normal? The banks are just, it's my experience that the banks are just strict on wanting something signed by a court. And my favorite is when someone comes to me and says, the bank said I have to probate the will. And I said, oh, is there a will? And they go, no. And they go, but I need to probate the will. And I think that's always the bank's response. So I don't know that your experience was normal, Brian. I don't know if you want to comment on that, Rebecca.
I've seen it where they do, like, even if you're going in and you just want to cash out the account with letters of testamentary or whatever, a lot of times the banks are requiring you opening up a estate account, which requires its own tax ID number. So you have to go in and get the tax ID number from the IRS site, and then open up a bank account in the estate of, and then you can put it in there for 5 minutes and take it all out. But a lot of banks are requiring you to open up the account.
Thank you for clarifying, Rebecca. Thank you. This question is, are the courts accepting oaths with the unsworn declarations, or does the oath have to be notarized? I think you went over this in your presentation. Do you just want to repeat it?
Yeah, they're accepting unsworn declarations right now that we're doing Zoom hearings. I don't know if they're going to continue to do that after Zoom, but for right now they are.
Okay. I'll repost the CLE information for the people who are asking. Just 1 second. And you're getting some kudos on your presentation. So thank you so much. And we're at 1 o'clock, guys. I don't know if you have any more time, Rebecca. I can stay in a few more minutes, but we said it was till 1 o'clock. I've reposted the CLE information. Oh, how long do you recommend administrators keep the estate accounts open? Do you mean a bank account open, or do you mean the administration open with the court, Angela?
Well, either way, you want to get them open and closed as soon as possible. There's actually timelines in the statute where if it's not done by a certain date, you have to give a court a report on why it's not done. And so you want to get all the property transferred into the beneficiary's name or into a trust name or something like that so that you can close out the probate, especially if it's independent.
I will just say that, so another probate practitioner told me that they don't actually close the probate action in the court. The court will drop it from its docket once you've completed all the things, but that allows you to order letters of administration for as long as you need to, as long as the administration's not closed.
So
yes, you have to self-report the CLE. Okay, well, I want to thank everyone for coming. I want to thank everyone for all the questions. I actually love the interaction. It shows to me that everyone's paying attention instead of doing something else on their computer screens. I want to thank you for all the helpful information, Rebecca. And And that's all. Thank you, everyone. Do you want me to stop the recording? Is this?
Well, no, there's another question.
Oh, okay.
Aaron, to access bank account funds for an affidavit of heirship, a lot of banks won't take affidavits of heirships. You have to do a determination of heirship. And in a determination of heirship, a lot of times you have to have an attorney do it because you're representing the estate. You're not representing yourself, so you can't do it pro se. Some of the lower banks, the ones that aren't as popular, they might accept an affidavit of heirship, but usually like the Bank of America, Wells Fargo and stuff, they are requiring the determination.
They want something signed by a court. They want that reliance.
Yes.
I'm also going to say that I've had someone come to me when they thought their spouse's account or something was payable on death, and some new person goes, "You have to probate the will." And I called the bank and they go, "Yeah, it's payable on death. Come back with the death certificate," and it was fine. So always check that too.
Yeah. And sometimes if you call another person at the bank, you can get a different answer anyways. So I've had to do that multiple times.
Okay. And Catherine has posted the section of the code regarding court-ordered access to the account. Thank you, Catherine. Okay. Then I'm going to go ahead and stop the recording now and thank everyone for coming.